Welcome to online study of law of torts. Before our discussion on the law of torts, we should have some idea what is civil law and what is crime. Every human being has some rights. What are those rights? First, he has a right of his own body and life. Second, his right of protection of that is property. Third is his reputation, that is dignity. So life, property and dignity of a human being are protected by law. I do not say about fundamental rights. As a human being, a person has rights to live with dignity, with all facilities of life. Even for that, various laws are there made by the state to protect this right. Whenever this right, legal right of somebody is violated, then that is, we say that is a wrong. It is a wrong. Violation of somebody's legal right by another is a wrong. This wrong may be of two types, that is one is civil wrong and the other is crime. When a wrong affects a particular person but doesn't affect the society, that is a civil wrong. But when a wrong affects the society at large, we say that's a crime. In case of civil wrong, but first it is a wrong in personam. In case this crime, that is a wrong affecting the society, wrong in rem. Second is that in case of civil wrong, what is the remedy? The remedy is either getting compensation, money compensation, or restoration of property. But in case of crime, the remedy is to punish person, to punish that person, punishment. In case of civil wrong, that is the person against whom a wrong is caused, he takes the law into motion. He seeks remedy in his private capacity to get compensation or restoration of property, or to get back his property. In certain cases also, to prevent the person for an injunction, restraining that person to commit such breach of his legal right. But in case of crime, the state takes the law into motion, and state takes the responsibility to see that the criminal is punished. So the tort is a branch of the one kind of civil wrong. So you should have an idea what is civil wrong. When a wrong which affects a particular person, it doesn't affect other society. That is called civil wrong. In case of civil wrong, the person against whom wrong is caused, he takes the law. He comes to the court. He approaches the court to get this remedy, for enforcement of his right, either for getting compensation. But in case of crime, the state takes the law into motion. State takes the responsibility to see that the criminal is punished. Whenever fine is realized, that goes to the, in case of crime, that goes to the state exchequer. But in case of the compensation which is realized, that is paid to the person against whom a wrong is caused. So, law tort is one kind of civil law. So, here this tort, prior to the British establishment of Mayor Courts in Calcutta, Bombay and Madras, the tort, this law of tort was not known to India. That was a foreign law. But only the mayor courts in Calcutta, Bombay and Madras, they administer justice in these courts upon the common law and statute law of England. They administer justice by following the common law and statute law of England, which were suitable according to the Indian condition. So this led to introduction in those courts the jurisdiction of the English common law. English common law was introduced. How? Because mayor courts were established. Those courts are authorized. They are empowered to administer justice according to justice, equity, good consent, and applying the common law of England. So thus, the English laws, the legal system, was introduced in India by the mayor courts. Later, the Supreme Courts, which are established sometimes later in those three towns, Calcutta, Bombay, Madras, the Supreme Courts are established. They replace the mayor courts, were modeled on the English pattern and had some jurisdiction and authority as the courts of kingsmen. They function as the courts of kingsmen, held in England by the common law of England. So here, this, that is English law, was administered by the Supreme Court in Calcutta, Bombay and Madras. But the common law courts, in the exercise of their ordinary original civil jurisdiction, as distinguished from this appellate jurisdiction, that is the jurisdiction to hear appeal from decree of English common law. These courts have been established by Act. Almost all, that is, local and the Act establishing them contain each a section which require them in the absence of any specific law usage, act according to, in absence of specific law, they are authorized to act, decide cases according to justice, equity and good conscience. This is according to the rule of England. So gradually, they also applied the law of torts in certain cases in India. So now, this law of tort was introduced by the Britishers. Then, this is the origin of law of tort in England, India. Then what is tort? You know, if sometimes a question is, what is tort? Somebody says, tort is a civil law. Remedy is only liquidated damages. But you should understand the definition of tort correctly. Tort is a civil wrong other than breach of contract and breach of trust. Other than breach of contract and breach of trust, the remedy is unliquidated damages. If you understand this tort is a civil wrong other than breach of contract or breach of trust, the remedy is unliquidated damages. What is unliquidated damages? Unliquidated means that the amount is to be fixed by the court. Parties have not determined that. The damages, the money compensation paid for damage is called damages. So tort is a civil wrong other than a breach of contract or breach of trust. The remedy is unliquidated damages. The term tort is the French equivalent of the English word wrong. So the tort is a French word. It is equivalent to the English word wrong. And the Roman law, delict. Tort is called, in Roman law it is called delict. In French it is called tort. It is equivalent to England law, it is called wrong. It was introduced in the English law by the Norman jurists. In England, the law tort, the tort was introduced by Norman jurists. The word is derived from the word term, which means the twist and implies conduct which is twisted or tortuous. The conduct which is tortuous. The term that is wrong, which means twist. It now means a breach of some duty. If they say it is a breach of some duty independent of contract, giving rise to a civil cause of action. It is a breach of duty. Other than an independent or it is not out of contract, giving rise to a civil cause of action, and for which compensation is recoverable. The best definition is tort is a civil wrong independent of breach other than breach of contract or breach of trust. The remedy is unliquidated damages. The basic principle underlying tort law is that what it is, no one should be harmed by the act of others. The basic principle on which the law of tort is based is that no one should be harmed by the act of others. There is a duty of care towards everybody for peaceful living in the society. Law protects the right of the individuals, and when a right is protected, the other has a duty to respect that right. So that's why there is a duty of care towards everybody, which is impliedly imposed on the law. Impliedly, duty is imposed on everybody to respect the right of others. In spite of various attempts, entirely satisfaction definition of what tort still awaits its matter. Still, this satisfactory definition of tort is lacking. To provide a workable definition in general terms, it is a workable definition. A tort may be defined as a civil wrong independent of contract for which the appropriate remedy is an action for unliquidated damages. So, a civil injury for which an action for damage will not lie is not a tort. That is a civil injury for which action for damages will not lie. That is not a tort. That is, suppose say for example, public nuisance. Public nuisance is also an injury, but for that one cannot claim damages under tort, but for private nuisance, he can claim damages. That is a tort. So because public nuisance, because a civil injury for which an action for damages will not lie, though it is a civil injury, like a civil injury, but no damages, no action can lie for the alienation of damages. That is for public nuisance. The person committing a tort or wrong is called, the person who commits a wrong is called tortfeasor. Tortfeasor. The person who commits the tort is called tortfeasor. And his misdoing is called tortious act. His act is called tortious act. The principal aim of the law of tort is compensation of victim. First, second, no one. There is a duty of care to everybody. No one should be, there should not be breach of legal right of anybody. That is, when law has given somebody a right, that right must be protected. The principle of the law, aim of the law of tort is to compensate the victim. Compensate the victim or their dependent, either to the victim. Suppose say for example, motor vehicle accident. They are the victim. Somebody dies, they are after the dependents. They claim compensation. So the principal aim of the law of tort is to compensate the victim or his dependent. The general principle for award of damages in tortious claim is therefore compensatory. It is compensation. Our grant of, there may be, in certain cases, there is exemplary damages. In certain cases, that is to deter the wrongdoer is also another aim of the law of tort. By awarding exemplary damages, that also some extent deters certain kind of wrong. For us, that is, for exemplary damages, somebody makes a false, the allegation of unchastity. That is, their exemplary damages is given. So now, what is you? By now you are aware what is tort. Tort is a civil wrong. Tort is a French term. The equivalent meaning of tort is wrong as per the English law. Then under the Roman law, it is called delict. It was introduced into England by Norman kings, Norman Juris. Norman Juris, they introduced this law of tort. The word tort is derived from the Latin word tortum, which means to twist and implies conduct which is twisted, or that is the conduct is called tortious conduct. The person who commits tort is called tortfeasor, the act is called tortious act. Now you are clear about what is tort. Now let us, you should understand the difference between tort and contract. In case of contract, there is offer, acceptance, and free consent. And when a contract, when a breach of contract takes place, the law compels a person to keep his promise. If a person doesn't keep his promise, then he is to compensate the other. But in case of tort, no consent is there, no offer, no acceptance. But because here somebody's legal right is breached, so there is very much distinction between law relating to contract and a tort. A contract is founded upon consent, whereas a tort is inflicted against or without consent. In case of the contract arises because of consent of parties. But here, in case of tort, such consent is not without consent. An action for breach of contract necessitates privity between the parties. There is privy parties, private capacity, they enter. In tort, no such this privity is needed. A tort also be distinguished from pure breach of contract. In a tort, there is also a right, violation of right in rape, or right vested in some determined person. So, right vested in, or as a member of the community, but in available against the one at large. Whereas the breach of contract is infringement of right in person, suppose it is in a particular person. So, suppose the A assaults B or damages B's property without lawful cause of action, excuse, it is a tort. Here the duty to violate violated is a duty imposed by the law. Suppose X had agreed to sell a particular goods to Y, but he did not keep his promise. That is only X. The Y had a right against X only. So there may be a such situation. There may be but in certain cases that there may amount to a tort and also breach of contract. For an example, such as carrier. A carrier, goods are entrusted to a carrier. There is a contract. But suppose damage occurs to the goods. So there may be tortious act. Or a surgeon, a father, or that's made a contract with a surgeon for the treatment of his son. Suppose there is negligence in treatment, then son can realize damages as per the law of tort. But so far as father and surgeon is concerned, their liability is under the contract. So here, there may be some cases. In several situations, the same act may amount to a tort and also breach of contract. Persons such as carrier, solicitor, surgeon, who undertake to discharge certain duties and voluntarily enters into a contract. They undertake to discharge certain duties and voluntarily enter into a contract for the performance thereof. will be liable for neglect or unskillfulness, either in action for a breach of contract or in tort. Either way. There is negligent in treatment. Then the doctor is also liable under the law of torts for compensation, to compensate. So here, that is some situation. In some situation, the same act may amount, the same act may amount to tort and also breach of contract. Same act. That is, a father, for an example, a father employs a surgeon to attend on his son. The son is injured by unskilled treatment. Here there is a contract between the father and the surgeon, but none between the son and the surgeon. There is no such contract. The father therefore may sue the surgeon under the law of contract, but the son can sue the surgeon under the law of tort for his negligent in treatment. So in this context, the celebrated case, the famous decision, the landmark decision is the decision on doctrine of negligence, that is Donahue versus Stevenson, ginger beer case, popularly known as ginger beer case. In this case, the manufacturer who sold the substandard article to a retailer, who sold it to a customer, was liable to a friend of the customer, who after consuming it became ill. Suppose manufacturer and retailer, they had entered a contract. The ginger beer was sold by manufacturer to the retailer. Retailer sold it to a customer, and customer failed, consumed it and became sick. There the customer failed, sued for damages. Because it is though the same act, there is a contractual liability between this manufacturer and the retailer, but under the law of torts, the manufacturer was under a contractual duty to the retailer and was in breach of that duty, but he was also had a duty to this under the law of torts to take reasonable care not to harm a customer. So customer was entitled to realize compensation as in the case, some living case, Donahue versus Stevenson. So the distinction law relating to tort and the law relating to contract, the fundamental sound are getting, because sometimes it is blurred in certain cases. The duty in a tort is independent of any consent. You should understand. Under the duty under the law of tort, there is no consent or agreement. But under the contract, the parties entered into an agreement, they are consented. The more onerous duty of care owed by an occupier to visitors. Similarly, the same, it may be observed in the fundamental duty in the contract to perform the promise. In case of contract, the fundamental duty of the parties is to perform the promises, to keep their promises. Like a tort, duty comes into being a mere force of law. In case of tort, there is a breach of duty. There is a infringement somebody's legal wrong. That is, in the days, that is like a contract for some, presuming common calling, that is a farrier, a smith, an innkeeper, a surgeon, and a common carrier was liable in damages for failure to extract that skill which was normally expected person pursuing the calling, and though later it became possible for one who entered into it. The same act, in certain cases, the same act may give both contractual liability as well as liability under the law of torts. So you should have, by now you are aware what is the difference between tort and contract. Then the difference, you should know what is the difference between tort and quasi-contract. Quasi-contract. Quasi-contract, you know, because of some situation, a person is liable to another without an agreement for money or benefit received by him. That is under the law of contract, because of this finder of loss rule, this is a supply to a minor or an innocent person. These are quasi-contract. Quasi-contract cover those situations wherein a person is liable to another without an agreement. Because of such situation, a person is liable to another because of some peculiar situation. But is liable to restore the benefit which has received from that situation. According to the orthodox view of the judicial basis of the obligation, under a quasi-contract is a hypothetical contract. It is hypothetical contract which is implied by law. Because of some relationship, all those contracts, though there is no for acceptance, but still the contractual liability is there. According to that is, the obligation under a quasi-contract is imposed by the law. Obligation under the quasi-contract is imposed by the law for the reason that the defendant has been unjustly enriched. No person will be allowed to be enriched unjustly, and that expenses of the plaintiff. No person should be unjustly enriched at the expense of the plaintiff. The law relating to quasi-contract differs from the one relating to tort in that there is no duty owed to person generally for the duty or repay money. So, the law relating to quasi-contract resembles to the law of tort and differs from the one relating to contracts. On one aspect, that is, the obligation in it is not the tort but is imposed by the law. It is not on the breach of right, but because of law imposes a duty on somebody in a quasi-contract. So there is one aspect in which quasi-contract differs from both tort and contract. Because under the law recognizes that somebody is liable. This can be explained that nobody must be enriched at the expense of the plaintiff. So this can be taking a familiar example of quasi-contract that when A pays money under a mistake to B, B is under obligation to refund it. Suppose by mistake A pays some money to B, B has an obligation to refund it. For an example, suppose while doing the bank transaction through this that is digitally, or there may be some wrong payment in the another person's account. So that is, though there is no contract, but the liability comes under the quasi-contract. Even though the payment is voluntary and is not induced by fraud or misrepresentation. So, but still the person who has made a payment mistake is entitled to realize that amount. That is quasi-contract. In this, so it cannot be said that there was any primary duty on him not to accept the money paid to him under a mistake. Suppose why that the other person in whose account wrongly money was that is credited, he must not refuse it. But in tort, but still he has a duty, the remedial or secondary duty to refund the money under the principle of quasi-contract. So but in the tort is also a contract. There is always primary duty. In case of tort, there is a primary duty of the breach of which gives rise to a remedy. So this is the difference between tort and quasi-contract. Okay, so what is the difference between tort and crime? A tort is also very different from a crime. First, a tort is an infringement of privation of the private or civil rights belonging to individual. But a crime is a breach of public rights and duties which affect the society at large. So that is difference. In case of crime, the punishment is there. In tort, the wrongdoer has to compensate the injured person, whereas in crime, he is punished. Thirdly, in tort, the action is brought by the injured person, but the proceedings are conducted in the name of the state. In case of crime, that is civil law. Civil law and crime. Because tort is a civil law, this is the definition. So, the law of tort is fashioned as an instrument for making people adhere to the standards of reasonable behavior and respect the right and interest of one another. This constituents of tort. The law of tort is prescribed as an instrument for making people adhere to standard of reasonable behavior and respect the rights and interests of one another. So this it does not protecting interest, and by providing for situation when a person who is protected interest is violated can recover compensation. So that is this difference between crime and tort. Then in the next class we'll discuss what is wrong. What is wrongful act? What is wrongful act? That is the injuria sine damnum, and then damnum sine injuria. Thank you.